Thank you very much for coming to the Registrar of the African Court to have this interview, which is an initiative to enhance the visibility of the court to the African people. My name is Robert Eno. I'm the Registrar of the African Court. I'm from Cameroon. The role of the registrar is like a CEO in a company. I do the day-to-day running of the registry of the court. I provide technical, administrative, and judicial assistance to the work of the court to ensure that the judges perform their task as effectively as possible. The founding instrument of the African Court is the protocol to the African Charter on Human and People's Rights on the establishment of an African Court on Human and People's Rights. And this protocol was adopted in Ouagadougou, Burkina Faso in 1998. As I indicated, it's a protocol to the African Charter. The African Charter, we can call it the Human Rights Bible on the African continent.
Taking into account that the African Commission was already in existence, what do you feel were the reasons for establishing an additional continental mechanism?
Thank you. That's a very important question because so many people have asked that question. Why do you have an African court and an African commission doing almost the same thing? I think from the name itself, the African Commission is simply a commission. It is a quasi-judicial institution that was established under the African Charter on Human and People's Rights to promote and protect human rights on the continent. The African Commission started its work in 1987, and it receives complaints from individuals on alleged human rights violations. At the end of the day, the African Commission makes recommendations to states if it finds that there has been a violation. It makes recommendations on what states should do to remedy the violation. Unfortunately, many of the recommendations of the African Commission were not implemented by states. And it was thought one way to reinforce the African human rights system because of this weakness in the African Commission was to establish a court. I think the idea was that a court, which is a judicial institution, will give legally binding judgments, and those judgments will be implemented by the states concerned. Unfortunately, as we've seen over the years, that has not happened. Even the judgments of the court, some of them have not been implemented by states. As a matter of fact, the majority of them have not been implemented by states. So the main reason why the court was established was to enhance the work of the African Commission to fill in the gap, at least in the area of protection of human rights.
Kindly explain the jurisdiction of the African Court.
The African Court has two main jurisdictions, or it exercises two main jurisdictions. There is a contentious jurisdiction, which has to do with receiving complaints, cases on alleged violation of human rights against mainly state parties to the protocol. And this jurisdiction is exercised in a number of ways. The court has the jurisdiction to receive cases from individuals, from NGOs, and from member states or state parties to the protocol. It can receive cases directly from state parties to the protocol, but it cannot receive cases from individuals and NGOs, except those individuals and NGOs are filing cases against a state that has deposited a declaration, the declaration required under Article 34.6 of the protocol, which allows the court to receive cases from individuals and NGOs. If a state ratifies a protocol but does not deposit that declaration, it means the court will not have the competence to receive a case from an individual and NGO. And even if you're an NGO, you must show that you have observer status before the African Commission, before you can file a case before the African Court. The second jurisdiction exercised by the court is the advisory jurisdiction. And this advisory jurisdiction is for the court to give its opinion on any legal or human rights issue relating to any issue relating to the interpretation of a human rights instrument a state has ratified.
Who can file an advisory opinion?
In terms of the protocol, Article 4 of the protocol, I think there are 4 entities that can file an advisory opinion before the court. A member state of the African Union, an organ of the African Union, the African Union itself, and an African organization recognized by the African Union. So I can repeat that again. A member state of the African Union, the African Union itself, any organ of the African Union, and an African organization recognized by the African Union. On the last issue, there has been some interpretation given by the court on what constitutes an African organization recognized by the AU. So many people had thought that if you have observer status before an African Union organ, say for example the African Commission in Banjul or the Committee on the Rights of the Child, you are an African organization recognized by the AU, but in the interpretation of the court opined that having observer status with another African Union organ does not necessarily mean that you are recognized by the African Union.
Does a person need to be a lawyer to have right of audience before the African court?
Not necessarily. You don't need to be a lawyer. We've had cases where applicants before the court may have been represented by non-lawyers. Maybe they are jurists, but you don't necessarily need to be a lawyer. Non-Africans can file cases before the African court as long as they meet the conditions provided for in the charter, admissibility conditions in the charter, as long as they prove that they are representing or they have a power of attorney to represent their clients before the African court. And of course, as long as the case is brought against a state that has deposited a declaration.
Is there a charge to file a case before the court?
No. The court does not charge any fee for filing cases before the court. As a matter of fact, the court makes provision for legal assistance. If you can prove that you are indigent, you cannot afford a lawyer to represent yourself before the court can actually provide you with legal assistance.
How does one file a case?
It is very easy to file a case before the African court. If you have access to internet, you can send your case by email. We have an address, registry@africancourt.org. You send your case to the registry, and it can actually be dealt with without you coming to Arusha. It is that easy. If you want to send it by post, we have our address on our website. There are some applicants who can afford, and some applicants come to the registry and file directly to at our registry. And then when you file, we acknowledge receipt. We give you an indication to show that we have received your application. Once that is done, it is registered, and the process moves from there. It is sent to the relevant department within the registry for processing, and then taken to the judges for a determination as to whether the allegations you've made are true or false.
Is there a format for the application?
Yes, we have developed we have developed a form to facilitate the filing, because in the past we realized that applicants were filing cases in different formats. Some of the applicants were not covering some important points that will help the court to make a determination on their case. It delayed because the court will have to write back to them to seek additional information. So we've developed a form which is on our website, and we've been encouraging applicants to use that form. It is very simple to complete. It is broken down in different sections: the name of the applicant, the name of the respondent state, the facts of the case, the rights alleged to have been violated. Yeah, so it gives a breakdown of what should be in an application, so that even if you're a layman, you should be able to complete that form and have your case dealt with expeditiously.
What are the official languages of the court?
The official languages of the court are the official languages of the African Union: Arabic, English, French, Portuguese, Spanish. We now have Swahili that has been introduced, and other African national languages. So apart from these 6 that I have listed, which are also the working languages, will become the working languages of the court. If you file your case in any African language, the court has an obligation to translate and provide you interpretation in case you are required to appear before the court. Yes, it is a general principle of international law that you exhaust local remedies before you come before the court. As a matter of fact, before you go before any international tribunal. It's a general principle. This is to give the state the opportunity to solve the matter before the state is dragged into an international arena. However, there are exceptions to that principle. If you can prove that the case is unduly prolonged at the domestic level, maybe the government is frustrating the process just to prolong the case so that maybe you can abandon the case. You can prove that the domestic remedies are not available, or they are not capable of dealing with that problem. Then you can bring your matter to the court without necessarily exhausting those remedies, because they are either unduly prolonged, they are either not available, or they are either not effective or sufficient enough to deal with the matter that you are complaining about.
You mentioned earlier that the court offers legal assistance. How does one access this legal assistance?
When you are applying or when you are submitting your case to the court, you can at the same time apply for legal assistance. You can indicate that you need legal assistance, to pursue your case because you do not have the means to pursue your case. And within the court, we have a committee of judges that will look at your application and make a determination as to whether you require legal assistance or not. We've granted legal assistance to quite a number of applicants, most of them prisoners, who demonstrated that they could not afford to hire a lawyer, they could not afford to financially pursue their cases that they are brought before the African court. So you just need to indicate that you need legal assistance. It's not a complicated process.
And before filing a case, are there instances where the court has offered drafting assistance to indigents?
No. Before filing the case, no. I think we can only know that you need assistance when you file the case. Yeah, that cannot be before. And we've not had a situation where an indigent has written to the court to say that I want to file my case, can you provide me with assistance? We've not had that situation.
How does one become a registered legal provider for the court?
Usually we organize trainings for would-be legal providers or legal assistance providers before the court. We do have on our website what we call a legal aid policy, where we are trying to train quite a number of lawyers to be able to appear and litigate before the African court. So in that policy, we have outlined certain requirements that you must meet to be able to be trained and be put on the roster. So one of the requirements is that you must be registered in the bar in your country. Secondly, you must have practiced for at least 5 years. Yeah. So from time to time, we receive applications from lawyers all over the continent expressing their desire to be part of the roster of counsel for the African court. And when we get a number of applications, we pass it through the committee of judges. They look at them, they accept those that meet the requirements, and then we invite them for training. So far, we've trained more than 100 lawyers. Some have been used as pro bono lawyers. They have taken up cases before the court, even though we have not really operationalized the legal aid scheme. But they are very eager to appear before the court, so some of them even work on a pro bono basis. Yeah.
Kindly explain how else someone can become involved in an ongoing case.
If you are not part of the lawyer's trade, you can act as a pro bono lawyer. You can request the court that you want to provide your services to provide legal assistance to indigent applicants. You can also maybe want to act as an amicus curiae, to be a friend of the court, provide information to the court that will enable the court arrive at a just decision. You can provide even research. We have memorandum of understanding with some institutions. They provide us with research on certain issues which will help the court make a determination on particular issues. Yeah, so there are quite a number of ways you can get involved in the work of the court, not necessarily through being a lawyer.
Does the court hold hearings for all cases?
We hold hearings, but hearings are an exception. I think over 90% of the cases before the court are dealt with through written pleadings. The court holds hearings only where it is seeking clarification on issues that are not clear in the written pleadings. That is why I say hearings are an exception. And hearings also are quite expensive. It means the parties will have to come before the court. We have not developed the practice of moving the court to the applicants as some tribunals do. Rather, the applicants come before the court here in Arusha when we organize hearings. So we try as much as possible, if what is contained in the written pleadings is enough for the court to make a decision, there's no reason for a hearing.
Does the court hear evidence from witnesses?
Yes. The court gets evidence, even if it is based on the written pleadings. We receive evidence from witnesses. We've had occasion to hear witnesses on some particular cases, and given the opportunity for those witnesses to be cross-examined by the other parties. So even in our rules, we provide for the receipt of witness testimony as part of a fundamental part of the justice delivery system. There are instances where, I think we've had at least one instance where a witness that was called by one of the applicants was challenged by the other party, and the court had to rule that, okay, the witness should not give evidence. So it is quite an important element in the work of the court.
Please explain the difference between an intervener and amicus curiae.
An amicus curiae is a friend of the court, and an amicus curiae can request to be a friend of the court, and the court can also request an individual or an institution to act as an amicus curiae, to provide it with information based maybe on the expertise of that particular institution. I think we've done that for the Institute on International Law, African Institute on International Law, to provide us information. We've done that for the Office of the Legal Counsel to provide us information. Yeah. So an amicus curiae comes as a friend of the court. On the other hand, an intervener is someone who wants to be included as part of the process, either because they have an interest in the case, and if they don't intervene, the judgment of the court may affect their interest. Yeah, for example, a state party whose national has been brought before the court by another state may want to intervene to protect their national. We've had a situation where nationals from Kenya, for example, have brought a case against Tanzania that their rights have been violated by Tanzania. Kenya may seek to intervene in the matter because it is their national. So they want to protect the rights of their national. In our recent rules of court, we have provided for the possibility where even individuals or other entities other than states can intervene. Because we had a situation where we delivered judgment in a particular case, and some other entities thought that judgment will affect their rights but they did not have a way to intervene to demonstrate the extent to which that judgment will affect their rights. So we've now included that in the new rules, that entities other than states should also have the possibility to intervene.
Does the court have an appeals mechanism?
No. The decision of the court or the judgment of the court is final. You cannot appeal the judgment of the court. We don't have an appeals chamber where you can appeal. However, you can write to the court for the court to review its judgment. And for the court to review its judgment, you must demonstrate that the information you are bringing to the court was not in your possession or in the possession of the other party at the time the court was making that decision. Yeah. So the only avenue available to parties, which is not an appeal per se, is a possibility to seek for a review. But and you must seek for this review, I think within a period of 5 years or so. And the conditions are very, very strict. We also have the possibility of you requesting for the court to interpret its judgment. That is not an appeal. It's just for if you don't understand the judgment, you cannot implement the judgment, for example, you can come back to the court for an interpretation of the judgment to make it clearer. Yeah.
In terms of implementation, who has the primary role in ensuring implementation of decisions?
The primary responsibility to implement the decisions of the court lies with the parties who came before the court. In most cases, it is a state. Yeah, because in any case, the primary responsibility to promote and protect human rights lies with states. So when a judgment has been delivered or any decision has been taken, the responsibility to implement that decision lies with the state. However, there are instances, for example, if the court grants an order for provisional measures. We've had an instance where the court has requested the state not to take certain action and for the applicant also not to take certain action. Yeah. So even in that situation, I think it is a responsibility of the state to make sure that that decision is implemented. Yeah.
Expressly has put an aspect of implementation. Kindly guide us through the process and also include whether this has been implemented to date. Can you tell us?
We noted that implementation of the decision of the court was left almost entirely to a political process. When the court makes a decision, it reports to the Executive Council. The Executive Council is the one now to follow up on implementation of the decision. We've realized that this has not worked. The majority of the decisions of the court have not been implemented. Maybe because the Executive Council has not put in place mechanisms to ensure implementation. So in the new rules, the court looked for a way how it can itself be involved in monitoring implementation of its decisions. Yeah. So it has provided for the possibility of compliance hearings, whereby if a decision has been adopted by the court, the registry will send a decision to the parties concerned, and provide a template and a timeline for the implementation of that decision. I will constantly be in touch with the state for the implementation of that decision. And the registrar will prepare a report to the court to indicate that this is what is happening with the implementation. If by the time given, the deadline given by the court, the decision has not been implemented, or if it has been implemented but one party is not satisfied, then the court can invite the two parties for a hearing on the extent to which that particular judgment has been complied with. Yeah, after that hearing, I think there will be clarifications, and the court will now make a determination whether there has been compliance or not, and then issue a report.
Kindly explain the implications of the withdrawal of Article 34.6 declaration and what this means in terms of filing cases.
Article 34.6 simply grants to individuals and NGOs the possibility to bring cases against states that have deposited the declaration. Because by depositing the declaration, the state is saying that I recognize the jurisdiction of the court to receive cases against me from individuals and NGOs. Yeah. So if a state deposits that declaration and grants that power to individuals to do so, and later on withdraws that declaration, it means that it has prevented those individuals or citizens from that country from accessing the court. The consequence of that is that citizens of that country or anyone who has a case against that country can no longer bring a case against that country before the African court. And it means that the purpose for which this court was established, which is to give an avenue to citizens, African citizens, to access the court if they are not satisfied with justice at the domestic level, that is defeated. So far, I think there are about 4 countries that have withdrawn their declaration, and they have given different reasons for doing so. And you may want to know that the court is engaging with not only these 4 countries, but with all member states to discuss some of these concerns that states are raising, and to see how to effectively engage with member states in the execution of the mandate of the court, because member states are the ones that decided to establish the court. Member states have established the court, and member states have the primary responsibility to protect human rights. So it's important to engage with them. If there are concerns that they have, they can raise those concerns and see how to enhance the work of the court.
Is there another route individuals can still access the African court after Article 34.6 has been withdrawn?
Yes. Individuals and NGOs can access the court. We call that indirect access, whereby you can bring a communication which is similar to an application before the African Commission, which is based in Banjul. You can submit a complaint before the African Commission, and the African Commission can then decide to bring that case before the African court. The Commission is not obliged to bring the case before the African court, but if it chooses to do so, it can bring the case before the African court. And when it brings the case before the African court, it is bringing the case in its name, not in the name of the applicant who went before the African Commission. So the African Commission now provides another route, especially for citizens of those countries that have withdrawn their declaration under Article 34.6 of the protocol.
Can the court consider a case that has been considered by another regional, continental, or even international redress mechanism?
No. That is one of the requirements under, I think, Article 56 of the Charter, which provides that cases that have been settled by other international mechanisms, whether they are regional or international, cannot be entertained by the African Court. And we have cases that have been settled by the ECOWAS Community Court of Justice and brought here, and we have rejected them. We've rejected them. Yeah. So no, the court cannot.
In situations where a case is dismissed at admissibility stage before the merits are considered, sometimes because the applicant has no standing, by a different applicant who has standing, can it be deemed admissible?
Yes. If a case is dismissed because one of the criterion for admissibility have not been met, the applicant or any other applicant can go and remedy that particular requirement and come back to the court. For example, if your case is dismissed or declared inadmissible because you've not exhausted local remedies, you can go back and exhaust local remedies and still come back to court. If it is dismissed because maybe you did not identify yourself, or because it was written in a disparaging language, you can go and rectify all of that and still come back to court. Yeah, whether it is you bringing it back or some other applicant, as long as you have cured the defect that led to the matter being declared inadmissible, I think you can bring it back to court.
On the issue of reparations, is there a guideline applicants should follow? And if it is there, is it available to the public?
We have adopted guidelines on reparations, which went through a serious study, and I think it is available to the public. I think this is a copy I have in front of me. Yes, we conducted a study, and this study is on our website, and I will have to check whether the guidelines are also on the website. But I don't think it is a document that cannot be shared with the public.
Now, on the proposed extension of jurisdiction of the court, can you kindly give us a guideline of when it is likely to be enforced, or what conditions are necessary for it to come into force?
If I may start with a brief background, the African Court on Human and People's Rights is established by a protocol, the Ouagadougou Protocol, adopted in 1998. The protocol came into force in 2004. The judges were the first judges were elected in 2006, so the African Court became operational in 2006. Meanwhile, I think in 2003, the African Union adopted the protocol on the Court of Justice of the African Union. And in 2008, the African Union adopted the merged protocol to merge the protocol of the African Charter on Human and People's Rights with the protocol of Court of Justice and the African Union to form the Court of Justice and Human Rights, African Court of Justice and Human Rights. The protocol adopted in 2003, the protocol on the Court of Justice of the African Union, has obtained, I think, 19 ratifications. So ordinarily, this protocol should have come into force because it required 15 ratifications. But because in 2008 it was merged with the African Court on Human and People's Rights through the merged protocol, its operationalization could not happen. And this merged protocol has obtained only, I think, 3 ratifications, so it cannot come into force. And then subsequently, the African Union decided to develop another protocol, which is protocol to the amendment of the protocol of the Court of Justice. Yeah, this is a Malabo protocol, which now includes the criminal aspect. Yeah, so with all these protocols, we now have a situation where there will be established one court with 3 different sections. The human rights section, which will be like the current court, the criminal section, and the general service section, which is a court to deal with interstate relations and things like that. But the Malabo Protocol has not been ratified, at least as at last month, has not been ratified by any African country. Yeah. So to answer your question as to when we envisage this court to come into operation, I cannot tell you, because the protocol was adopted in 2014. We are now in 2022. I think that's 8 years. It's 8 years, huh? Yes. And there's no ratification. And we need 15 ratifications. Yeah, so I cannot give you a time frame. But what I can say is that I'm sure the current African Court on Human and People's Rights will continue operating for a long time to come. Yeah. There has been talk to operationalize the Court of Justice of the African Union because the protocol has already come into force. We don't know how that will go, but the court envisaged under the Malabo Protocol, I don't see it coming into force anytime soon.
Have any states filed cases against other states?
Before the court? No.
And to wind up, what would be your advice to potential litigants?
Well, I will advise potential litigants to consider a number of things before filing their cases before the court. One, they must ask themselves whether the state against which they are bringing their case has ratified the protocol. We know that all African states except Morocco have ratified the African Charter. Yeah. So you ask yourself whether the state has ratified the protocol. 2, whether the state has deposited the Article 34.6 declaration. Yeah. And if they have not deposited, you may now consider whether to go to the Banjul Commission. 3, you should ask yourself whether you have the means to bring the case before the court. And if you do not have, you request for legal assistance. If you are a lawyer, you should determine whether your client needs an order for provisional measures to repair irreparable harm to your client. For example, if your client is on a death row, your client is going to be executed soon, you have the responsibility to make sure that does not happen. So you can apply for an order for provisional measures to prevent that from happening. Let me conclude by thanking Palu for this opportunity to bring the court to the African population. As we know, one of the challenges we are facing as a court, not only the court, many African institutions, is lack of awareness. Very few people on the continent know about the court, and even those who even know about the court do not know some of the processes we have discussed, how to access the court, how to bring their cases before the court, the possibility of applying for legal assistance before the court. So I think this is a wonderful initiative, and on behalf of the registry, I wish to thank you for this initiative and hope through this the court will be better known by many Africans. So thank you very much.